Each side will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. If you will let me know whether you wish to have any time reserved, I will keep the time and let you know when we get to that point. We've read the briefs and we're ready when you are. Thank you.
Good afternoon. May it please the court, my name is Kathleen Amerkadian, and I am representing appellant mother in this case. This case involves a finding of dependency and a grant of legal custody. The dependency was found...
Excuse me if I could just interrupt. I don't believe you indicated whether you wish to reserve any time.
Thank you very much for reminding me. I do wish to reserve 5 minutes for
All right. Go ahead.
The statute at issue is the dependency statute ORC 2141.04, which allows for a finding of dependency when there is an older child of a parent who has been adjudicated dependent or neglected or abused, but also requires that there be an additional finding that not only was an older child in the household adjudicated, but that the conditions of the child at issue also justify a finding of dependency. This court has previously addressed the constitutionality of this statute and has emphasized that the reason the statute is constitutional is because there is not an irrebuttable presumption that just because a parent has an older child adjudicated, that the next child will also be found dependent. So in making that determination, this court has emphasized that there must be an existence of a causal connection. In this case...
You mean causal connection between the previous case, and if so, what aspects of it?
There has to be a relationship between what was found in the previous case as far as why the child was adjudicated neglected independent and the current conditions of the child at issue.
How specifically? Is the conduct have to be identical or simply sufficient to reach a conclusion that the child needs protection in the first case, and then the second case it may need protection for different specific reasons?
The case law interpreting the statute and finding that there is a causal connection, it appears to be factually dependent, and there have been specific facts present in prior cases where you have parents in the second case who are not complying with the case plan, where there's evidence of drug abuse, where parents are not even allowing children's services access to the home. And so the case law does not really address how specific that causal connection has to be. However, in reviewing that case law, there are many aspects involved in those cases that just are not present in this case. In this case, we do have a very serious prior incident with father, where he was criminally charged and convicted of child endangerment or felony assault with the child, and the child was gravely injured. However, he served his prison sentence. It was roughly 10 years later. And also, mother, who I represent, had not been involved in that prior incident at all. So fast forward to the present with the child BB. Father is cooperating. He's left the household upon Children's Services request, even before the complaint for dependency was filed. Mother is not allowing father to have any unsupervised contact with the child. They are attending parenting classes, they're asking for more parenting classes than they were required. There is no issue of basic needs not being met. In fact, there's ample testimony that both parents were actually very good parents. And there were no actual instances of any kind of outburst by father or any instances where mother was found to have not protected the child. So in applying this statute to these circumstances, there is such a lack of a causal connection that, as stated in the brief, really this is a case of an irrebuttable presumption, that there was nothing that father and mother were going to be able to do to alleviate the concerns of the agency. And there's nobody saying that these concerns were not serious. However, the law does not provide, under the statute, the ability for children's services to simply skip this causal connection.
The agency, excuse me, took into consideration, I think reasonably, that mother was working full-time and that father would be the primary caregiver, if I'm not mistaken. We have two cases that I'm trying to keep them separate, but both of them are with the agency. And in this case, as I recall the briefs, it seemed as if the agency felt like, even though mother went through the things that she was asked to go through in terms of reunification, that she minimized the risk to the child, and the agency felt that notwithstanding the classes, et cetera, that she just didn't seem to get the potential harm to the child. As I recall, the first child was 5 weeks old at the time that he was injured, and that at the relevant time here, the child was 5 months old, but certainly too young to protect himself or to, relate anything that might happen. Was it unreasonable for the agency to have concern?
It wasn't unreasonable for the agency to have concern and certainly to get involved in the first place. But after a certain passage of time where there are no incidences of any problems, where mother actually testified that she didn't just leave the child with father when she went back to work. She had a couple of months where she observed father, where she did not really allow him to have unsupervised contact and before she went to work. So she went through a process, she testified, of having her concerns alleviated. But furthermore, you also have ample assessments, mental health assessments of father. You have ample observations between father and the child. You have the GAL testifying that there's a very strong positive bond. And so to maintain that that there's no acknowledgement of the risk, even though the risk actually never surfaces over that period of time, I think becomes unreasonable.
Did both of the mother and father indicate their intention to reunite and live together after this case was over? That was the impression I got from reading the brief.
The mother testified that she had spoke at length to the agency about the various options and stating that if the agency would be satisfied by her not reuniting with father, that would be her intention. I mean, she had, of course, did express the desire that she would like to reunite with father, But she had stated if that's what it takes for her not to lose legal custody of the child, that that's what she would be willing to do.
I got the impression that the court considered that statement in the context of another statement that mother had allegedly made regarding whether she believed that father was responsible for the injury to the other child, and seemed to suggest that, she believed that he was not at fault, but perhaps the child's mother or whomever else was at fault. So in the context of that statement, if the court had that before it, would that not raise some reasonable concerns?
I do acknowledge that the concern is legitimate. However, eventually the concern has to be validated, and it has to be compared to, the court's action has to be compared to what the statute requires. So I also want to make the point, though, that related to that when the parents both made some reference to mother of the older child potentially being involved, that was because at some point in time during that investigation, there had been speculation that the older child had been injured through a period of time and not all at once. In those references, father and mother still acknowledged that father was the one who took responsibility for the injuries. He had his own ideas as far as how the injuries occurred, but there was really nothing before the court to indicate how those injuries occurred. So, the agency continued to hammer home the point that he's not taking responsibility.
Well,
But
he
did.
maintained that he bounced a 5-week-old baby on the bed and gave it such severe injuries that it wasn't intentional, it was bouncing the baby on the bed. I mean, he maintained that, it appears from what the judgment entry says, that up until the very end here, he maintained that he bounced the baby on the bed.
He did, and
Excuse
I
me for
still...
just a moment. I want you to respond to my colleague's question, but I also want you to know that you're into your 5 minutes, so if you want to continue on, you may. I mean, by all means respond, and then this is just my warning to you regarding the time. Go ahead.
Thank you. Looking at the record, I don't think that there is anything in the record showing exactly how those injuries occurred. And so all we have really is people found it hard to believe. However, there's no evidence as far as, the agency didn't go through and present evidence as far as what how the injuries were actually occurred.
I guess, and to that end, the baby, a 5-week-old baby can't testify, and neither can a 5-month-old baby
Right,
testify. So you're kind of flying by the seat of your pants here when you're trying to figure out what happened, and there's nobody to testify as to what happened with the alleged perpetrator.
And it's important to note, though, that case was handled. He spent 7 years in prison for that. He's not coming in, and this is not a case where, nobody's taking responsibility. He did take responsibility. He made good use of his time while in prison, and after prison, everybody testified he was a good father. So with that, I will save the rest of my time for my father.
Very well. Thank you.
Good afternoon. May it please the court, my name is Jennifer Goodall, and I represent the appellee, Lorain County Children's Services. I stand here today and I tell you that this child baby is safe. However, the reason he is safe is not because of mother's choices. It's not due to mother's protective instincts. And even with the implementation of the case plan, court-ordered case plan services, it's not due to mother's personal growth and acquired insight. It's because of agency intervention and court orders.
Let me ask you a
Yes.
question right off the top. I was a little confused about the position of the GAL below.
Yes.
Did the GAL recommend that legal custody be granted to mother?
Mother had legal custody at the time of the further dispositional order. There was only protective services or protective supervision. So the GAL recognized the level of risk that was posed to the child with father being involved and mother's minimization of father's risk. However, the GAL did not advocate removal of custody from mom.
Okay.
So the GAL would have preferred a lengthier period of time of agency and court involvement.
Okay. Thank you. That's helpful.
Mother has challenged the lower court's rulings at various stages. So I want to clarify, she challenged first at the adjudication and then later at the further disposition. And that's the two time periods that she's brought to the court's attention. With regard to the adjudication, counsel previously referenced ORC 2151.04, which is the statute regarding dependency. So the court would have to find that the child resided in a household in which a parent had abused a sibling of that child, not necessarily an older child, but a sibling, and that because of the circumstances surrounding that abuse, that this child is now in danger of suffering abuse from that same person. So mother incorrectly asserts that the trial
Because
court...
of, go back for just a second, because of the circumstances now existing?
Correct.
Is that what you said?
The circumstances in the past,
Right.
where the abuse occurred, and the circumstances now that parallel that past situation.
And what are those circumstances other than the fact that he has been convicted 10 years ago?
Well, at the time that the prior abuse occurred, the child was an infant, unable to protect, unable to ask for help or report. He was a sole caregiver, and nobody else knows what happened at that period in time, but it took one incident for that severe life-threatening injury to occur. Now we have an infant again, who is young, unable to protect, unable to report. He's the sole caregiver for long periods of time when mom's at work, 10 hours at a time. And the other adult involved has no intention of trying to entertain any additional protection of that child because she feels that he is no harm to that child. So aside from the time period that's passed and his incarceration, they're the same.
So, given that analysis, is there anything that could happen to change the position of a person who was previously, long time ago,
Absolutely.
convicted? Because it just seems like, as your opposing counsel indicated, it has turned into an irrebuttable presumption.
And I would assert that it's not.
Okay,
He,
convince us.
in the past, conducted some type of action that injured this child. Now, if he were to engage in services, he would evaluate what occurred. He would do some introspection, he would engage in counseling services, he would figure out what his triggers are. He would address those triggers. And then through that counseling and those services, he would be able to alter his future behavior when encountering frustrating or situations that anger him, so that when caring for a child by himself, he can utilize those coping mechanisms in order to not be a risk to that child any longer.
And did he do that
No, he did not.
at all? He didn't do anything?
He participated in parenting classes, however, the counselor stated that at some point he got stuck, and that mom and dad who were participating in the services were not able to, the next session, reiterate or summarize the lessons that had been taught at the prior session. So even though they walked the motions, they didn't internalize or demonstrate any type of personal growth or insight into the circumstances.
You know, this is a very difficult job for the agency.
Yes.
Because it's almost as if you're, predicting the future. I wonder sometimes, and particularly when I read a record like this that has some very general statements about, they appeared not to understand or to be able to appreciate. It's not hard facts, and so it makes you wonder whether, the agency is looking into the mind of someone and trying to determine what they're thinking, and how you can do that.
Yeah, at some point, it is a hard decision, but it's also the court's ultimate weighing of the facts and the evidence and the credibility of the witnesses. They are the individual, the magistrate or the judge that's hearing the case are the individuals that are going to decide. So the agency's going to do what they're going to do. They're going to bring it to the attention of the court and present what they have. And not only are you going to have the agency's testimony, but you're going to have mother and father's testimony. And the court's going to determine whether that's credible and whether the court needs to intercede in order to make sure that that child is safe. And if mom and dad walk the path that the court gives to them, and the case plan itself says that they need to demonstrate these things after following through with the services, if they demonstrate those things, then everybody's going to leave and they're going to feel that that child is safe.
I guess that's the issue. The easy cases are the ones where the case plan is set up and the parents don't show, or they, don't cooperate, and they close the door and say you can't come in and do a home inspection, and those are the easy ones. The more difficult ones are the ones where the parents do show up and they go through, they do what they're asked to do, and then it's the agency's evaluating the progress that they've made that seems subjective.
Now, in this case, though, if you look at the testimony at the adjudication, where the magistrate found, and I think I have a quote from the magistrate actually, that it's overwhelmingly clear that the conditions that led to the abuse and near fatality of BB's sibling have not been remedied, and that would place this child at further risk. So the testimony and evidence at the adjudication caused the magistrate to be so severely concerned about this child that he adjudicated him dependent. And then if you look at the testimony and evidence at the further dispositional hearing, almost a year later, we're in exactly the same point. And in fact, we even have father at one point testifying that he doesn't have a problem with maintaining a calm demeanor, and he doesn't have shifts in mood, but then in another place he says, sometimes it's like a burning pit. That's his own testimony.
Now, is this the case where the sheriff had to be called in the, that's the next one, sorry.
So,
Or may have had a question.
Well, I was going to ask for more specifics on why and how the agency reached its, you said it was, they say it was just conclusory. Will we find in the record specific allegations that say the father or mother as well disregarded a recommendation that has been made to them, and they have some hard evidence of that, or are they just simply have this sense that we all get when we deal with our children, whether they're telling us the truth or not?
now with regard to recommendations in the case plan, for example, father was ordered to go for a psychological evaluation and follow all recommendations. He did go for the psychological evaluation, but he refused to follow through on the recommendations, which was the counseling. Right. And in his own testimony, he felt he didn't need it.
Okay, we have documented in the record those facts.
Correct.
Okay.
And we also have documented in the record mother's failure at the beginning from the beginning of the case to the end of the case to have any change in her understanding of the risk that father poses.
She always maintained, well, he's been to prison, he's done his time, it's okay.
Yes, and in one point in the case, she actually said that she referenced father for some parenting advice because he had more experience. The experience he had was the experience with the prior child that he abused and was sent to prison for. So she didn't have parenting experience. She looked to him, and then he spent long periods of time parenting this child. And then all the way to the end of the case, he wasn't given that opportunity again because the court ordered him not to be in the home until he had satisfactorily appeased to the concerns that the court had. So the child was protected.
Was it ever, I guess my question is, I know there was long periods of time, it said up to 10 hours when mom would be at work. Was it ever suggested to her that, why can't you put this child in childcare so he's not with dad for 10 solid hours?
I don't know that the record reflects that, and I don't personally know. I know that at the time the agency initially became involved, I believe they had minimal resources, and that is why he was the primary caregiver while she was at work.
Typically, that's what we see.
Correct.
Well, somebody was on Social Security, weren't they, disability? No?
I don't think so.
It's a mix.
I'm just wondering why Title
Can
20
I
or
have
something
a
wasn't
time
in there.
check?
Yes, you are at 3 minutes and 47 seconds.
Okay, I am going to wrap this up then. So we have summarized that mother and father did follow through with some of the case plan services, but it's the agency's assertion that they did not internalize any of the case plan services, what those were teaching throughout the entirety of this case. And so upon the conclusion, the court, the standard that the court uses is what's in the best interest of that child. And the court, almost a year before, had determined that the child was in serious risk because of father's past behavior, the current circumstances, and mother's unwillingness or inability to protect. Those were still the circumstances almost a year later. And so the court had to make a decision. Do we bow out? What changes are really going to be made? If no changes are going to be made, do I feel safe leaving this child in this home? And the court did not feel safe. So we made a very difficult decision, but a necessary one. And so the court at that point placed the child in the care of someone who would protect him and would keep him safe. This court actually has ruled that the law, and this was in Ray Jones, the law does not require the court to experiment with the welfare of a child to see whether that child will suffer great detrimental harm. And so the trial court was not willing to experiment with the safety of this child. And so I appeal to you to affirm the trial court decision and to keep this child safe. Thank you.
So you have a little over 2 minutes because we have so many questions.
Okay. The primary thing I wanted to point out was the issue of father not complying with recommendations. He went to the psychological assessment. It resulted in no diagnoses. The assessor did recommend counseling. He never stated that he did not feel like he needed counseling. He asked the agency if they would help pay for counseling. He could not afford the counseling because there was no diagnosis attached, so he was not able to get in on a sliding scale. The agency testified that their response was they were not going to pay for counseling because they did not think that there was anything he could do to alleviate the risk. Now on appeal, they're stating if he had just gone to counseling, he would have alleviated the risk. I don't think that that argument is consistent with what they conceded at trial. The second issue with regard to the mother's protective capacities, it was the agency's own witness, Bob Reitman, who was the parenting court mentor who worked with mother and father and testified that he saw absolutely no concern with mother's protective capabilities. And I think that the observation that the agency is kind of trying to peer into the parents' heads to speculate as to whether the parents really internalized everything is a very dangerous tack, especially in a case where you have a specific requirement by statute that there be a causal connection between the prior harm of the prior child and the child's current conditions. The only causal connection that they can come up with is that both of them were young children. I would submit that that is just not enough to meet the statute. It's so close to an irrebuttable presumption. If there are no other questions, I'm just rest. Thank Thank you.
Thank you both for your presentations. The court will take the matter under advisement and will issue a written opinion which will be sent to both parties, and you may check the Supreme Court website as we post our decisions.
Thank you.
Thank you.
Thank you.